Members, it's the appointed time, and we have a quorum. I call to order the meeting of the Bills Committee. Staff members, please invite representatives of the administration and deputations and individuals to come inside the conference room, please. For today's meeting, it is a public hearing to hear submissions on the bill. We have 19 deputations and individuals attending today. I will first ask deputations and individuals to speak, and then I'll ask representatives of the administration to respond to the views. And then the floor will be open to members to ask questions, and then the administration will give a response. The administration will give a detailed written response on the submissions received by the Bills Committee, as well as the views expressed today.
歡迎局長。Winston 喺嗰後邊。歡迎政府嘅代表。
Welcome, representatives of the administration as well as deputations and individuals. Deputations and individuals, please note the following. 1. If you need simultaneous interpretation services, you may put on the headphones. Channel 0 is the floor audio. Channel 1, Cantonese. Channel 2, English. Channel 3, 普通话. Each will have 4 minutes to speak. The timer in the conference room will make a sound at the 4-minute mark to remind deputations and individuals that their time's up. Please note that your submissions or your speeches neither will be protected by the Legislative Council Powers and Privileges Ordinance. Please also note the note for members of the public attending meetings in conference rooms or observing meetings in public galleries in the electrical complex. The notice can be found before you. Please note the rules in the note, including keeping in order. Please do not shout or chant slogans, nor can you display any signs unless you have received approval. If you have prepared speeches, please write down your names on the speeches. Before you leave the conference room, please hand your speeches to staff members for the reference of the Bills Committee. I will first ask Dr. Mandy Wong to speak. 4 minutes. Thank you, Chair. All along, we have paid close attention to the development of the harbourfront on the connectivity as well as accessibility. We have a group of young people in the past year and the year before that conducted studies, and we have surveyed 100 odd residents in the Central and Western District. 85% of them said they would visit the harbourfront at least once a week, and 50% of them would visit the harbourfront more than 3 times or even every day. It shows that citizens love using the harbourfront. And we also have a study last year. As you may know, in the Central and Western District, there is a harbourfront section in Kennedy Town. It has become a hot photo-taking spot. It has become quite a popular site in Xiaohongshu, so we have visitors as well as citizens going to that section. But the problem is the visitors and citizens would be competing for access with road users, that is drivers, and that is because there is not much of a pavement there. So for this reason, we think not only should we focus on connectivity or accessibility, we have surveyed on this issue with residents, and 80% of the residents thought that they want to have a boardwalk in the area, and they would want the ordinance, protection of the harbour ordinance, to be amended for the reason of public safety, because people are competing for access in that section. And of course, we want to facilitate people taking photos for their memories, but of course public safety is a concern, and 60% of the survey respondents thought that the harbourfront was very important, and it would be best if they could connect it to the end. And close to Cadogan Street, there was a harbourfront section that was open, but it has been broken off from the rest of the harbourfront. It is not easy for residents to access that area, and residents wanted this to be fixed. So apart from accessibility, as I said earlier, they think public safety is a concern, and that's why I would like to share what residents think about this particular section with members on this issue. And for some minor works or non-permanent works with the bill's provisions, some restrictions can be relaxed. I hope that representatives of the administration as well as LegCo members can facilitate the passing of the bill as soon as possible to make it more convenient to take forward such works. On another issue, with the works completed, we need to make sure we are using the right materials to make sure it is environmentally friendly for the ocean. While the works may not be permanent and the works may be smaller in scale, but if we have an elevated boardwalk, even that, we will need some foundations to be made. So I hope we can take into account this issue. Thank you. Next, Mr. Yang Hopming. I am a district councillor in the Central and Western District. Since the handover, residents have been asking for the harbourfront to be open for public access. Unfortunately, due to the restrictions in the ordinance, in the Central and Western District in particular, it is hard to develop the harbourfront to be a connected harbourfront with the restrictions of the ordinance. So the harbourfront is broken up. Today, I'm here to support the proposed amendments to the ordinance. I also urge LegCo members to support the passage of the bill so that we can relax restrictions to carry out necessary works in the Victoria Harbour to facilitate public access to the harbourfront. And for the harbourfront, to provide quality experience and services to citizens. We have been developing boardwalks or harbor fronts in different areas, but we can see that in many parts they are broken up, not just in the central and western district. If citizens want to have a connected jogging trail and they can enjoy the side of the Victoria Harbour, they can't due to the restrictions in the ordinance. While the administration may want to take forward such projects, and citizens actually do want this to happen, and those facilities will be facilitating the public, they still can't be taken forward without the proposed amendments. So I support the passing of the bill, and I hope that, subject to the passage of the bill, the administration can take forward works as soon as possible to connect the harbour front to facilitate public access and provide the public with a better experience in the harbour front. Thank you. Thank you. Mr. Ivanhoe, Chairman of the Harbour Front Commission. Good morning. Chairman, members, I'll first say Happy Valentine's. The Harbour Front Commission in the past 20 years has worked closely with the Development Bureau and other policy bureaus to construct an attractive, vibrant, accessible, and sustainable harbour front. In the past years, we have achieved great results. However, the protection of the harbour ordinance has a very stringent framework. We have our hands tied. For example, the boardwalk at the East Coast Park. From the conception of the idea to the test of the overriding public needs, it took 3 rounds of consultation, 10 years for the project to be submitted to the LegCo for consideration. The project team has been working very hard and did not give up on this. It is thanks to them that we have finally constructed the boardwalk. The Development Bureau and the Harbour Front Commission have worked together to improve the harbour front in the past 20 years. We understand that there is now higher public expectation of the harbour front. With the proposed amendments, we can have restrictions relaxed and take forward more works to harbour front so that there will be more possibilities. The SAR government said many times that they had no plans to conduct large-scale reclamation in the harbour for commercial or residential developments. And if we look at the history in the Victoria Harbour, such projects only took place before 1997 during the colonial era. After 1997, the SAR government never took forward such works. The protection of the harbour ordinance has been passed in 1997. It has been 20 odd years since. We now have a consensus to protect the Victoria Harbour. No one would want to challenge this premise to protect the Victoria Harbour. I think, on the other hand, it is now time to review the broad brush approach in the protection of the harbour ordinance, whether it is still appropriate at this time. With the proposed amendments, it will not undermine the principle to protect the harbour. Rather, it will put forward a comprehensive mechanism, and it will now be in the law so that there will be more certainty for project proponents to follow, so as to take forward the works to improve the harbour. The Development Bureau proposed amendments to this bill, and for 2 occasions they have consulted the Harbour Front Commission on the proposed amendments. members of the Commission and I support the amendments because we believe that would offer more flexibility to take forward works to improve the harborfront as well as the harbor. It will also provide more flexibility in the uses of the harborfront so that we can enhance efficiency and quality with the carrying out of the works as well. Thank you, Chair. Next to speak, Mr. Jonathan Leung, District Councillor of the Southern District of the Liberal Party. Thank you, Chair. I'm very glad to be here to express my views, specifically support for the proposed amendments to the protection of the harbour ordinance. For 4 years or so, I have been serving in the Southern District and I have been paying close attention to the issue. We think it is very important to make sure there is connectivity of the harbourfront due to the restrictions in the ordinance. There is not much connectivity in the harbourfront and citizens found it regrettable. We can see that the proposed amendments will bring about great benefits. Of course, there is a need to protect the Victoria Harbour, but we have now a change in circumstances. The public now views the harbourfront differently. People would just say the harbourfront is an icon. They will take pictures there. They would see that as a trademark, but now many citizens would actually visit the harbourfront. They would take a walk there. They would bring their children there. It is now different in the sense that how people use the harbourfront. We hope to strike a balance between conservation and development so that we can better make use of the harbourfront, so that at different times citizens can make use of the harbourfront to match their needs in daily lives. We have seen some having reservations about the proposed amendments, but I'm sure with the administration or electrical members, they should understand that, as the country says, it is very important to protect natural assets, but then it is also important that we are improving the harbourfront as well. If small-scale reclamation can make the harbourfront experience even better and facilitate public access and the public's use, we think it's well worth it. The Victoria Harbour is the asset of Hong Kong. We think with this bill's provisions, it will offer more flexibility for the future development of the harbourfront. So I urge members to pass the bill so that we can improve the harbourfront to meet the future needs of the public. Thank you. Next to speak, Mr. Felix Wong of the FTU. Thank you. I am a district councillor of the Kowloon district as well as a member of the FTU. The FTU has all along been paying close attention to the development of the Victoria Harbour. The Victoria Harbour is a landmark. It is an economic lifeline. It is also an important part of the public's daily lives. We have 4 suggestions in relation to the bill's provisions. We hope to have a zoning in the Victoria Harbour so that there will be more detailed zoning. There should be a core zone and an other zone. We will have the water body in the middle of the old runway excluded from the core zone. Right now, this zone is still in the protection of the harbour ordinance scope. We cannot take forward new works that has impeded the development of the area. With more detailed zoning, we should be better able to strike a balance between conservation and development. It will also provide flexibility for reasonable development in the area. Next, on conservation and development out of the water body outside the core zone. This water body would also be important. We should strike a balance between conservation and development while being able to conserve the environment. We should take forward more improvement works. We should have more public facilities. We should have more open spaces. We should also provide more social services. Not only will it improve the quality of living of citizens, it should also be able to appeal to visitors that will in turn provide sustainable development of the economy. Next, we hope to develop water taxi services that will facilitate public access. It will also alleviate pressure on the land transport system. It will also provide more transport options to visitors. We suggest that the routing of the water taxi services can run along core economic zones and tourist areas. This will improve passenger experience. It will also make the Victoria Harbour more attractive. It can also facilitate economic and cultural exchanges within the zones. Next, construction of the boardwalk network close to the harbourfront. We should expedite the construction of the boardwalk network along the harbourfront on Hong Kong Island and Kowloon. There should be a clear timetable to update the public on the latest progress and the expected completion dates. For example, in Kowloon City, the harbourfront section between Hong Kong and Kai Tak, there are 3 harbourfront lots for various reasons have not been connected. For example, close to the Green Island Cement Pier in Hong Kong, as well as the Kowloon City Vehicle Pier, as well as the gas facilities in the area. We can make use of the bill's provisions with the boardwalk with different designs. We can connect the harbourfront. There should be more flexibility, and it will provide a more complete harbourfront experience to citizens and visitors. Victoria Harbour is a landmark of Hong Kong. I hope that we can discuss with various experts and members today so that we can lay solid foundations for the development of Victoria Harbour. Thank you. Next to speak, Mr. Anson Lam of the Youth Liberal Party.
Chairman, on behalf of the Liberal Party, I speak in support of the amendment bill. Hong Kong has limited resources, and we understand that the government is facing some dilemma between harbour protection and development. And I think we should adopt a pragmatic approach to identify room for development. The Victoria Harbour is the germ for Hong Kong, is ecological, and a value cannot be underestimated. But the existing framework is really ossified. The amendment proposes moderate degree of reclamation, and this is on the condition that the harbour will not be severely affected. There are suggestions that the Kwun Tong reclamation should take place, and it should be connected up with the runway to maximize the use of land resources. If the typhoon shelter in Kwun Tong were to be filled in, then it would affect the facilities there, and I think that there should be alternative facilities to protect the interests of the fisher folk. With the onslaught of typhoon shelters would be terribly important for the operators, but this cannot be implemented under existing PHO, and the Kai Tak terminal is really running short of car parks. I think there can be a platoon that would be built to provide ferry services to enhance the services. And the platoon would only take up a small proportion of the sea surface, and it doesn't really affect the operation. And this is a balance between preservation and development. To take forward Hong Kong's development, we have to be scientific. We cannot be too conservative at the expense of the well-being of the public. The amendment is pragmatic. The Liberal Party urges everyone to engage in sensible and rational discussion, having regard to all views, and develop Hong Kong in a suitable manner. We should have a Hong Kong which is more livable and more accommodating going forward.
Harbour Vice Chairman, Mr. Winston Chu.
Thank you, Chairman. Honourable Councillors, our society is only objecting to paragraph 3H amendment in respect of large-scale reclamations. Without the present ordinance, by now Hong Kong would have already lost its harbour. The 26 kilometres of harbourfront promenade and improvements to the harbour would not have been possible. The present law operates as follows. The government is the proposer of the reclamation, and the law court is the judge of its legality. The 3H amendment proposes a fundamental change and completely reverses the process. Instead of the law court, the government itself becomes the judge and decides whether there is an overriding public need for its own reclamation proposal. The government becomes both the proposer of reclamation and the judge of its legality. This directly contravenes the fundamental principle of natural justice and the common law that no one can be a judge of his own cause. The common law demands fairness and justice. Decision makers must comply with the following rules. He must be unbiased. He must not have any interest in the matter. He must not financially benefit from it. And justice must not only be done, but seen to have been done. By the Clause 3H amendment, the government, being the proposer and becoming the owner of the land produced, contravenes all these three rules. The government argues that if you don't like our decision, you can always challenge it by judicial review. This is a lame argument, and this is not how justice works. The minutes of EXCO meetings are confidential, so it is always extremely difficult to challenge an EXCO decision, especially when the decision is empowered by law. Instead, the law itself should be fair and just. The present ordinance places the burden of proving an overriding public need on the government, which must produce its EXCO minutes to the law court. Governments change and government policies change. The ordinance provides the only reliable long-term protection for the harbour. The harbour attracts international attention. It is unwise to lay Hong Kong's system of the rule of law open to international criticism, where there is no need to do so. Hong Kong people expect that the principle of one country, two systems, and the basic law are not mere empty words, and that the promise to apply the common law, not a mere empty promise. Our system of government and the rule of law are on trial here today. Hong Kong people are relying on you as their legal representatives to protect their harbour by supporting the present ordinance and not the paragraph 3H amendment. Our society has never objected to small-scale reclamation nor temporary reclamations. In fact, the idea of exempting small-scale reclamations came from our society. We proposed it to the government. We're happy that the government has accepted it. Therefore, we are not anti-government. We like to cooperate with the government to make, for Hong Kong people, a good harbour. But large-scale reclamation endangers the harbour. We're able to save the harbour only because we're able to get the support of the law courts in 3 separate law actions to stop 5 large government reclamation proposals. And it amounted to 584 hectares, 63 million square feet. Therefore, Today, you still have harbour because of the ordinance. The protection by the law courts is essential. You cannot afford to lose it. If the present ordinance passes and gives the power of control back to the government may change, the next government may want to reclaim, and there's nothing to prevent them from doing so. The only long-term protection for the harbour is the ordinance. Thank you.
下一位係 Mr.
Mr. Hardy Locke. I'm Hardy Locke. I'm an engineer. I'm also chairman of the Society for Protection of the Harbour. I'd like to set out the background of the ordinance to highlight its importance to Hong Kong. The ordinance was enacted in 1997. It was intended to regulate the reclamation proposal. 92.6%, overwhelming majority were in support of this. 300,000 people petitioned and signed in support. There was overwhelming support in the LegCo before 1997. And it was also supported by the Provisional LegCo. In 1999, the legislature further supported extending the PHO to cover the entire harbour. This ordinance is to protect the harbour. The High Court, the Court of Final Appeal, support all the details, and the harbour was spared 5 reclamations: Green Island, Central 38 hectares, Wan Chai 26 hectares, Kowloon Bay 300 hectares, Tsuen Wan 30 hectares. A total of 580 hectares were spared. As much as 6,300 square feet. In the CFA's verdict, Mr. Andrew Lee ruled that for reclamation that is going on, it would make the rest of the harbour that much more precious, and the rest of the harbour would be that much more important. The ordinance spares the harbour from becoming a narrow strip of 800 meters. And we're able to build 26 kilometers of waterfront promenade. The PHO has been operating very well. And there is no need for us to amend 3H. I don't think the administration should replace the law court to become the arbiter of the legality of any reclamation. And this is going against natural justice, and this is also against the fairness and justice principle under the common law. Thank you. Mr. Jeff Che, Chairman, members. I'd just like to focus my attention on one clause of the bill, and that is 3H regarding large-scale reclamation. 3H authorizes the CE in Council to determine whether there is a rebuttal against the presumption against reclamations. It will be for the CE in Council to sit in judgment. 3H is unnecessary, nor is it fully justified. According to the background information of the LegCo, Para 8 says that on different occasions the administration said that there would not be any attempt by the government to fill in the harbour for housing, industrial and commercial purposes. So there is no need for us to amend this provision. As to the argument advanced by the administration to put in place Clause 3H, that the background brief for Para 4B refers to the fact that the introduction of this mechanism is used to determine whether there is a rebuttal. Now, this is not sufficiently justified because with such a mechanism, you don't really need to go down the legislative path because you can do so by directions or guidelines. So the government has issued such guidelines. The Works Bureau in 1997, Technical Circular number 13, and also in 2021 there was number 9, Technical Circular. All these circulars, when the Court of Final Appeal handed down they happened before the Court of Final Appeal handed down the verdict. In 2004, the CFA handed down the verdict, and in August of the same year, the government issued a technical circular, that's Housing, Building and Land Bureau 2004 number 1 technical circular, in which it outlines the requirements for the protection of the harbour. All public officers and public bodies are given a set of guidelines as to how to handle the proposals for reclamation. So it is clear that instead of having such a mechanism, the government can issue the technical circular to achieve the purpose. And also, there is a lack of justification for this mechanism because this mechanism is in existence. And that's the number 1 technical circular in 2004. This has been serving us for 20 years. It has been serving us well. So clause 3H is not necessary, nor is it well justified. The other point I'd like to highlight is the number 1 technical circular in 2004, para 8.3, instructs the public officers, where necessary, seek expert opinion as to whether the reclamation proposal can fulfill the test of overriding public interest. Because this would avoid any conflict of interest, and it is in line with the natural justice. Because nobody should be the judge of one's cause. Thank you. Next, Mr. Sun from the ACTO. Chairman, members, I speak in support of the Protection of Harbour Amendment Bill 2024. There were problems with regard to the PHO. There are some provisions that are ambiguous. The government has to prove that there is overriding public need before reclamation can take place. But what does it mean by overriding public need? And there is a lack of specific definition there. So when it comes to reclamation, whether it is big or small, the government will have to devote enormous amount of resources and time to work out whether there is an overriding public need. And there is a lot of uncertainties, and this is getting in the way of the development of the harbour front. Now, with the amendment, there is going to be a mechanism for a large-scale reclamation, and the principle is sufficiently clear. And in this amendment, there is a specific mechanism. The government can exempt the reclamation with a statutory limit of 0.8 hectares. For larger reclamation, there is a formal reclamation for approval. The government says that this is not intended to form land for housing, industrial and commercial purposes. It is merely intended to put in place a mechanism to regulate the large-scale reclamation. And they are introducing a specific mechanism for the small-scale reclamation. Third, in these amendments, the tourism sector will stand to benefit in 3 areas. First, it will be conducive to the improvement of the waterfront. The Victoria Harbour is one of the most important icons in Hong Kong. It is one of the most important assets for Hong Kong. We have to jealously guard this particular asset. These amendments would help to improve the facilities at the harbour front. We can include the Greenway. We can improve the waterfront promenade to benefit the members of the public. Second, it will improve the facilities for public consumption, and there would be more places for people to engage in consumption, F&B, bars, or the performing venues. All these facilities are lacking in Hong Kong. It is hoped that with these amendments, we will be able to improve the waterfront there. Third, the amendments are conducive to the development of yacht economy. The yacht economy will bring value-added services to Hong Kong. If we can increase the number of moorings, it might involve small-scale reclamation of these amendments that will certainly be conducive to this development. Thank you.
Next one, New Thinking. Deputy Secretary General, Ms. Pan Yiteng. Chairman, members, Ms. Lin, Permanent Secretary, and members of the public, on behalf of New Thinking on this amendment bill, I'd like to give my opinions. In 1996, the PHO affirms Victoria Harbour as an asset, and there are 3 objective criteria for reclamation, including overriding public need and the lack of alternative, and also the minimal damage to the harbour. And a mechanism has been established to set the criterion for reclamation and provide an objective basis for assessment. The core change in the latest amendment is that the large-scale reclamations, decisions for that would be given to the Executive Council, and also the large-scale reclamations would be exempted from the need for overriding public need. And these involves major public interest, so we need to handle it cautiously. After the amendment, the CE will have the final decision-making power, and that's problematic. Executive Council itself is a consultative body comprising officials and appointed figures, and they lack support or a basis in the public. And with this change, the public may not know the rationale behind its decision making, and the public will not be able to monitor how the Executive Council will balance conservation and development, and how can it ensure that there is overriding public need. The government says there can be judicial reviews lodged, but JR is only a passive route to see whether the government has followed the proper procedures, and the public may not have adequate information to decide whether there should be judicial reviews. And the government insists that it has no intention for large-scale reclamations. But the key is about the system and whether there is active protective mechanisms, and not what the government thinks. For large-scale projects which remove the needs for overriding public need, and in place is just a provision of consultation, but that would reduce the level of public participation. I know enhancing efficiency and opening up more open space for public enjoyment is one thing, but you should not obtain those at the expense of public monitoring. If the monitoring is not there, even though your system is perfect, the government and the public could be isolated from one another. Victoria Harbour is a common asset of Hong Kong people. Hong Kong people should have the right to decide, and they are major stakeholders. And the new thinking asks the government to consider the following three options. One, that should be a legally binding public consultation mechanism to ensure that each reclamation project, regardless of its size, would have adequate space for public participation. And secondly, there should be an independent advisory committee comprising professionals to monitor the whole process. And thirdly, we need to lay down clearer procedural guidelines and criteria to ensure that the whole decision-making process is accountable and transparent. Protecting Victoria Harbour is related to our planning, and it also involves proper governance. The public confidence in it comes from whether the system itself is complete and fair. New thinking urges the government to consider views from various sectors and to enhance the amendment and to set up a more trustworthy mechanism. The next one is Mr. Hong Wan-Kee from Designing Hong Kong. I'm project director of Designing Hong Kong. All along, our role is related to the development of the Victoria Harbour. Several years ago, our goal is to promote Designing Hong Kong Harbour District. Our goal was that the public and the commercial sector can reach, and the public can reach a consensus on how to develop the harbour. And in 2004, the Harbourfront Commission, its predecessor, was formed, and we have not stopped our advocacy work throughout the years, and we have also promoted various initiatives like water taxi in recent years. Designing Hong Kong all along, together with the Harbourfront Commission, always proposed that if there are major reclamations, then more rationale needs to be provided. We also support a lot of improvement measures to the harbour, including the boardwalk under the island Eastern Harbour crossing, and also other limited reclamation projects. And these reclamation projects are done without the need to change the law, so the government and the public would know that we need to go for small-size reclamations without affecting public interest. And the principle of overriding public need, that is still a principle that needs to be preserved. It is effective, and because it's a principle with legal basis and rationale, we strongly object to the amendment in 3H, Clause 3H. We understand the government wants to expedite the reclamation-related works, but the government can only amend its own internal guidelines, and that can achieve the purpose of increasing efficiency without going to the extent of amending the PHO. And all large-scale reclamations have been initiated by the government, and the government should not itself become the decision maker as well on future projects. It should be left to the individual and independent courts to make the final decision. Even though the government says that it has no plan to carry large-scale reclamations, but that doesn't mean that in the future governments would not go down that path. We cannot expect that 20, 30, 50 years later, whether the government then will stay away from having large-scale reclamations. And a new term of government may have new projects. In the past 30 years, we have kept protecting our precious Victoria Harbour, which we take so much pride in. The latest amendment giving the government the ultimate decision-making power would pave the way for future governments being having a free hand to do what they want. And as for the exemption for temporary reclamations, we welcome that, but we urge the government should strictly monitor the relevant works and ask the government departments to minimize the time needed and the scale of the project. And there should be continuous communication with stakeholders, and the government must deal with various issues and try to reach a consensus before a project is launched, because we need to let the public express their views and understand more about the project. And in the long run, the views expressed can help make improvements to relevant projects. So therefore, I think we need to have the government issue reports in relation to the issue of overriding public need, and to let the public understand more about relevant projects. And Victoria Harbour is a valuable asset and one of the most precious resources of Hong Kong. The harbour has witnessed Hong Kong's development and changes. And now with the PHO, it's because of the PHO people can witness the changes and appreciate the changes to the harbour. And our generation is fortunate enough to have seen the story of the Victoria Harbour, but it's a harbour that is worth protecting and preserving. We need to leave this story to our future generations as well. Thank you. Next one is Campbell Group's CEO. Our group, as a stakeholder in the North Shore of Victoria Harbour, we have paid much attention to the development of the harbour, and now knowing the proposed amendment to the PHO allowing small-scale reclamation projects to take place, we very much welcome that. In the Victoria Harbour, we've noticed that all along, pleasure crafts and yachts have limited mooring places, and in the Chief Executive's policy address, it's mentioned that Hong Kong wants to develop yacht tourism. So if Hong Kong has larger scale marina facilities, that can be a boost to our local tourism. And yet, within the Victoria Harbour, only in Causeway Bay do we have a yacht club, and which is of limited scale. And we've hired a consultant to study the proper locations within the harbour to set up as a non-core location for a marina pier. And we found that Yau Tong Bay is a possible site. In Yau Tong Bay, which is to the east of Victoria Harbour, near Yu Mun, in this location, Yau Tong Bay, on the land there is connectivity with the MTR station, and the Cheonam Tunnel is also connected, and transportation is very convenient, and it's easy for the public to reach that location. And it can be used as a site for the marina facilities, allowing people to go to the eastern side of Hong Kong, the beautiful waters there like Clearwater Bay or Shekou or other coastal areas. And to develop a marina facility there would be a complement to the government's plan to build another marina facility in Tung Chung, which is in the west of Hong Kong. Developing the marina facilities in Yau Tong Wan is a good choice because it's nearer to the eastern side of Hong Kong, and the second reason is away from the core Victoria Harbour area, so it would not pose any impact on the sea traffic there. And thirdly, Yau Tong Bay has a historical site. It is well sheltered, so therefore it is a good location for limited size reclamations. Just by building a short breakwater will be enough. And in its past history, Yau Tong Bay used to be the location for wood factories and other old-scale factories. Most of them have now been demolished. If we develop Yau Tong Bay as a marina facility, then this can help beautify the whole nearby area. In our study with a consultant on the topic of small-scale reclamation within size of 0.8 hectares, just by looking at the construction of the breakwater, we find that the area is adequate for the marina facilities. But it requires more than a facility of breakwater. There needs to be pontoons and other facilities to provide convenience for visitors as well. So the pontoons, if they are to be included in the 0.8 hectares area, and the number of yachts that can be moored would be limited. And that can also reduce the effectiveness of building the pontoons. Therefore, we ask the government to provide some exemptions for the building, that is exempting the building of pontoons from the 0.8 hectares size. Thank you. The next one is ACOM Director, Mr. Cole. Thank you, Chairman and everyone here. I'm a consultancy firm On the case of Yau Tong Bay, I want to provide more technical opinions. In Yau Tong, conceptually speaking, you want to provide facilities for yachts to be moored. There needs to be a stable breakwater to be built to provide a tranquil location for yachts to be moored. And breakwater will occupy an area of 0.55 hectares. In the case of Yau Tong Bay, if we want to make good use of the water body there and to allow yachts to be moored, so the landing facilities could be formed or set up in a way that in a form that they're non-permanent, and they could make up another 0.56 hectare. So under the Yau Tong Bay development concept, to achieve what needs to be done, the overall area needed will be 1.2 hectares. Given that, we can accommodate about 990 yachts to be moored. For the demolishable pontoons to be included in the 0.8 hectare site, besides the breakwater, the pontoons would need to be reduced to 0.25 hectares in size to accommodate the visitors. And the number of yachts will consequently be largely reduced to about 90 that can be moored there. So the consequence is that in the Yau Tong location or area, even if the breakwater is built, provide a serene environment there, it still cannot, in a cost-effective ways, provide the facilities needed. Therefore, we propose that, technically speaking, in the amendment, the demolishable pontoons or non-fixed facilities or non-irreversible facilities can be exempted from the 0.8 hectares reclaimed area, so that besides Yau Tong, in other locations along Victoria Harbour, flexibility can be provided for the construction of landing facilities or other activities, facilities needed for public enjoyment, and also to make good use of the Victoria Harbour. That's the end of my presentation. Thank you. Next one is Leung Kong Yoi, Mr. Leung Kong Yoi. Chairman, members, officials from the Development Bureau, good morning. I am from the logistics sector. I've worked there for 40 years, and I've taken part in various discussions in the past on reclamation. More than 20 years ago, the Hong Kong government promised not to have large-scale reclamations in the harbour for commercial, housing or industrial purposes. And in the past 20 years, you've seen that the government has actually lived up to its promise. I support the latest amendment because with this amendment, some construction engineering projects can be undertaken. And while protecting the harbour, people can enjoy the benefits brought by the projects. In 2004, after the court case there, in light of the PHO, the reclamation projects allowed, most of them are related to transportation infrastructure. For example, Sha-Tin Central Link or others, and some only are permanent. And some of the projects, once they're done, the Victoria Harbour site involved is restored to its original state. And in 2002 and 2007, I was a member of a small group for development in Wan Chai. And in the process, I understood the difficulties of promoting various projects. Even though the project involved was the Central Wan Chai bypass, which actually is very important for easing the harbour, the island traffic from east to west. And in carrying out large-scale public consultation, and we obtain overwhelming public support to build a bypass because it is seen to have overriding public need. But because of the project, inevitably, we had to have small-scale reclamations. And so we had more and more discussions, and more time and resources were needed to settle those disputes. And besides transportation infrastructure, the transportation logistics sector is also concerned about pedestrian safety. Any projects that can improve on pedestrian safety, for example, in Kennedy Town, the new Prior area, there are the locations for people to take pictures, and there's a project to build the pedestrian boardwalk. And because of the existing ordinance, we cannot proceed with those projects as wished, even though tourists like taking pictures there. But for a major road, it is really not ideal not to have the relevant boardwalk to put in place for pedestrian safety. So existing ordinance is oversimplified, even if it can provide for projects providing much benefits to Hong Kong. If it involves small-sized or non-permanent reclamation projects, a final decision was kept delaying, and we cannot kickstart the needed projects. All transportation infrastructure projects need careful cost-effectiveness analysis. If there's a further delay to the project, then the public would fail to benefit from it in time, and ultimately the economic costs or the benefits would be undermined. So for a project that involves non-permanent, limited size reclamation projects, I think we need to adopt a more flexible attitude. Therefore, I support the amendment. Thank you.
明信章。
Next to speak, Mr. Vincent Ng. Thank you, Chair. Thank you, members. Thank you, representatives of the administration, for giving me the opportunity to speak here. Let me say this. I would like to share with you my experience working as the chairman of the Harbourfront Commission for the past 20 years. I agree with other representatives' views. In the past 20-odd years, the protection of the Harbour Ordinance had imposed restrictions on reclamation in the Victoria Harbour, and we have finally been able to achieve a fixed coastline of the Victoria Harbour that has laid important foundations for the development of the harbour front, and we have thus begun the work to make sure the harbourfront can be used by citizens. The ordinance is important in protecting the Victoria Harbour. What we have seen in the past 20 years, it has imposed unnecessary restrictions. We have seen many harbourfront improvement works that cannot be taken forward. Under the restrictions of the ordinance, all reclamation works would have to pass the overriding public need test. The test has a high threshold, and that has impeded the enhancement of the harbourfront. Many harbourfront enhancement works are popular among citizens, but it is hard to quantify the benefits of such works, nor are such works exactly necessary. That's why it is hard to prove that there is an overriding public need. When constructing some landing steps, for example, we have seen that to be regarded as reclamation. Also for construction of piers or on the beaches close to typhoon shelters, if we are to construct a boardwalk, that would also be seen as reclamation. Right now, under the protection of the Harbour Ordinance, there is no lower threshold for such minor works. For the larger scale works, even though it may be the case that we can prove there is an overriding public need. For example, the boardwalk in the East Coast Park. It is because there was no formal mechanism to follow under the ordinance. To be prudent, 3 rounds of consultation were conducted to prove the project had overriding public need. If we had to do that for every project, that would mean a lot of resources. That's why it has really tied the hands of the government, and that has essentially stopped development in the harbour front. I think there is a consensus to protect the Victoria Harbour. No one wants to make the Victoria Harbour any smaller. With the proposed amendments, I believe we can keep to the premise of not having to reclaim in Victoria Harbour to create land. And in fact, when I was the chairman of the Harbourfront Commission, members and I have discussed the amendments very much in detail. I believe the proposed amendments would relax restrictions so as to facilitate the taking forward of improvement works in the harbour front to better respond to public needs so that the public can use the harbour front better. Thank you. Thank you, Surveyor Francis Lam. Thank you, Chair. Good morning, members, representatives of the administration. I support the proposed amendments to the protection of the harbour ordinance, and since 2010, at different times, I was a member of the Harbourfront Commission, and I have heard several Harbourfront Commission members, chairman and ex-chairman, talk about the different restrictions posed by the existing ordinance. The existing ordinance indeed has imposed much restriction. I believe everyone agrees with the intent of the protection of the harbour ordinance, but it is very rigid. It does not offer flexibility. And it is because there is no flexibility. Many improvement works, many new ideas cannot be implemented. Even if one wants to take forward such projects, one may have to go through various court proceedings. It may be a waste of time and resources, so the project may not be taken forward in the first place. Now, the proposed amendments would provide some flexibility to carry out the government's proposals. There is also a public engagement mechanism. The Harbourfront Commission will act as the gatekeeper. As you may know, the Harbourfront Commission's composition is quite wide-ranging. There are professionals. We also have some Green Group representatives. We also have representatives from the Society for the Protection of the Harbour. It's not that it is a one-sided commission and it would only voice the government's views. There is actual consultation and oversight in the commission. And each meeting of the Harbourfront Commission is public. They're not closed. I believe the Harbourfront Commission is well posed to be a gatekeeper for the public so the public can rest assured. There are also restrictions imposed with the proposed amendments. It's not that it is limitless. So it's not opening the floodgate to large-scale reclamation as some viewed. I think for our past 20 years, we have built consensus to protect the Victoria Harbour. We will not carry out large-scale reclamation in the harbour. The protection of the harbour ordinance has imposed rigid restrictions, and with the circumstances changes, we did not have, say, the Kai Tak Sports Park. We did not have the West Kowloon Cultural District. We now have them, and we need facilities to tie in with these. We will need, say, new piers, say, for harborfront facilities, we also need to enhance them. The Canoe Union actually wanted to take forward many water sports in the Kai Tak waterfront, but they cannot do so. The Royal Hong Kong Yacht Club and the other water sports organizations also want to host some events, but they cannot do anything. As Mr. Vincent said, simply touching the sea would be seen as reclamation, and one would already have to go through court proceedings to take forward such works. Thank you. That's it from me. Thank you. Next to speak, Ms. Sam Locke, the convener of the Hong Kong Institute of Planners. Thank you. With the protection of the Harbour Ordinance, it is to ensure Victoria Harbour will be reserved for public enjoyment rather than used for residential developments. In principle, we support the proposed amendments. Right now, there is no explanation on the procedure and time frame on how the overriding public need test is assessed. There is no requirement for public participation. We consider it necessary to provide a clear mechanism and procedures for the protection of the Harbour Ordinance. We suggest all project proponents should prepare and submit assessment proposals to ensure that we can engage the public by providing them with such information for reference. We also need to engage professionals, just like what we have in the Town Planning Board and the Harbourfront Commission, so that the public and stakeholders may inspect the relevant documents as well as listen to the views of members. We also suggest that project proponents should prepare and submit landscape and visual impact assessments to ensure the marine landscape is not subject to adverse impact, and the quality sites of the Victoria Harbour will be preserved. For specific harbourfront enhancement works, especially those that would enhance public enjoyment, including promenade, boardwalk, landing steps, there should be simplified procedures that will be exempt from the overriding public need test. For non-permanent reclamations, we also support allowing special arrangements for exemption for reclamations with a reasonable scale and time frame. But there should be a deadline such as the 8-year deadline that is imposed in the proposed amendments to prevent abuse and essentially permanent reclamation. Thank you. I thank all deputations and individuals for speaking. I will now ask representatives of the administration to respond to the submissions. I will also ask members to press the request to speak the button now to indicate their intention to speak. Ms. Bernadette Lin, Secretary for Development. Thank you, deputations and individuals, for speaking. I have heard different views. I heard many views supporting the proposed amendments, and I heard many have expressed that they understand our intent for proposing the amendments. The premise is to enhance public enjoyment and to relax restrictions to take forward works that would help the harbourfront better perform its functions. In a way, we are also strengthening regulation. I think many of those attending understand this. We have also heard some dissenting opinions. They said that the proposed amendments have essentially taken away the court's functions to act as a gatekeeper, and the government would essentially be approving the works on their own. I think such views reflect that there is confusion and misunderstanding on the legislative intent and the actual provisions in the bill and the existing ordinance. The existing ordinance did not have any provisions saying that the government must submit their proposals to the courts for reference. In fact, let me tell you this. For the ordinance, in Section 3, it says that for all public officers and public bodies shall have regard to the principles stated in subsection 1 for guidance in the exercise of any powers vested in them. That's it. Even before the proposed amendments, as you can see in the existing ordinance, the executive would make a decision, and if there are objections, and we have seen that happen in the past, when there were objections, one would lodge a judicial review and then the matter would be decided by the court. This system is what we adopt today, and it will be adopted still after the proposed amendments are passed, and if they are passed, one can still lodge a judicial review. Some of those in attendance said we are changing the basic system of how the executive and legislature and the courts work with the proposed amendments. I would say this for development-related matters, say for outline zoning plans. It has all along been decided by the chief executive and council. It is not an advisory body, it is an executive body, and they would make decisions on such plans, and one may lodge a judicial review if they object to such amendments. It has all along been the case that the executive could make a decision. This is not a new system. This is what is in many pieces of existing legislation. So why are we saying that the chief executive and council for specific types of reclamation would have to make a particular decision, and the decision mechanism is set out in the proposed amendments? We are setting them out because we want to show that we have a clear mechanism. It shows the commitment of the government. Some said the government could just promulgate administrative guidelines, and then you would submit the proposal to the executive council. We shouldn't put that in law. In fact, it is exactly why we're putting it in law. We want to provide clear guidance. We want to provide uncertainty, and we are not afraid to have it set in stone. We also have a public engagement mechanism. We also have statutory deadlines to follow. Before, the courts wanted us to consider certain factors. We are not afraid, and we have put those factors in the proposed amendments for the executive to consider. It shows exactly the government's determination and commitment. Some have expressed that the proposed amendments may make it hard to lodge a judicial review. I do not agree. If the government has played as a gatekeeper and has done well, even if one lodges a judicial review, we will stand against it. I think the logic has reversed somehow, because I don't see in any way that that would make it harder to lodge a judicial review.
There is an objection that even if the government were to form land for housing, commercial and industrial purposes, will there be any changes in future? Now, we do have the guiding principles that the court in handing down the judgment would have regard to. These will become the gatekeeper. If the government is not doing a good job, I'm sure there would be backlash in the community. I'm sure that we will be facing the prospect of the judicial review. The key thing is to spell out all these principles. There are some deputations that made some recommendations, despite the fact that they support the proposal. And that is, we should have better public engagement. Let me reiterate a couple of points here. Now, for projects that the CE Council would have to make a determination, the public participation would be a statutory process. If you support our proposal to engage in projects that will enhance the enjoyment of the harbour, as long as they fulfill the criteria, we still would have very rigorous public engagement process. The decision rests in the hands of the financial secretary. Still, we would have some administrative guidelines to make sure that the departments or the proponents will consult the Harbour Front Commission. There are some remarks that the Harbour Front Commission meetings and proceedings would be open to the public. We would also consult the District Council and the stakeholders. In our communication with the Bills Committee, we have stated that should there be such proposal, before a decision is taken, as long as the application is received, we will post it on the web, and when the FS has taken a decision in relation to projects that are fulfilling all these criteria, then we will brief the panel on the details in the form of a report and let members know what projects have been approved over the year. I'm sure that would give us sufficient level of public participation. There are deputations that said that for certain projects, if we loosen up the restrictions and go ahead with the projects, they would like to see that the design is done appropriately. I must say that the PHO is only the first step. It's about whether the reclamation would get the go-ahead, but it doesn't cover all the minute details. The design and the details will still be subject to the existing legislation. Like we have the Foreshore and Seabed Reclamation Ordinance, whereby if reclamation is to take place, whether it is within the harbour or outside the harbour, this would apply whether there is any objection, whether there is any problem. And also the EIA ordinance, if EIA requirement is necessary, we will go ahead with the EIA. It doesn't mean to say that with these amendments we can do away with the EIAs. We have to be bound by all these legislative provisions. There are some suggestions that we have the definition of the harbour. Can we subdivide this into a core area and non-core area? Now, we're not going down this path this time, precisely because we appreciate that the public treasures the harbour. If we were to demarcate areas that are of secondary importance, then that there are doubts about the reasonableness of this approach is going to be really contentious. So we would be sticking with the definition of the harbour as enshrined in the ordinance. And within this area, what sort of projects will see a loosening up of the restriction, and what sort of projects will see more regulation? Now, there was a suggestion made given about the former runway. Now, how are we going to be regulating this? I think it all depends on the nature of the projects. Some deputations hope that should this amendment be enacted, we should lay bare all the improvement works like landing steps, the promenade, the piers. They like us to lay bare all the details of the projects. In the paper submitted to members, we've cited some examples that we heard members of the public would like to see happen, but this is not a wholesale list of all the projects concerned. Like all the projects proposed by the administration, we have to take a step at a time. We have to adopt an incremental approach. We have to take them forward in accordance with the list of priority. So it would be hard for us to say prior to the legislation or the amendment being enacted that certain projects would definitely go ahead. But I can share with members that there are some aspirations on the part of some members of the public. We are really minded to do it. As to how soon we will get on with these, it would depend on the availability of resources. Why we need to loosen up the restriction, it is precisely because we like to have an accessible harbourfront. We would have projects that would enable us to achieve this purpose. So much I have to say for the time being, Chairman. I know that there is very much consensus in the community that the government will be removing all these barriers. And I do hope that the Bills Committee will join us in getting this done and achieve this purpose. Thank you, Secretary. Members who wish to speak, please press the button. Dr. Tik Chi-yun. Chairman, thank you. Once again, my welcome to all the deputations. 4 minutes, sorry, beg your pardon, 4 minutes. Chairman, this is really a wonderful occasion for engagement. We hear the views, and the administration hears the views, and this is a very good, wonderful, interactive process. It shows that public interaction, participation is very important. There are two issues that are highlighted today. First, we don't agree, nor do we support any massive scale reclamation in the Victoria Harbour. If we can loosen up the restrictions and improve the harbour, we like to see this happen. And this is really dear to our heart. We approach this with the same overriding objective of improving the harbour or preserving the harbour. I'm really proud that we can jog on the side of this wonderful harbour. The government said already that there would not be any massive scale reclamation. But in this bill, through the CE in Council, under 3H, large-scale reclamation can still be considered by the administration. If the government doesn't really want to engage in the reclamation, why do they want the power? I mean, it raises the doubt that they might have this motive going forward. The Secretary, you are not going to be engaging in massive reclamation, but can you guarantee that the next term or the term after next will not do so? Now, with the power being conferred upon you, it might happen. Now, we said that the public consultation in the bill might be too simple. Can you be more specific about the way you're going to be doing it to set our mind at ease? Secretary, will you be elaborating further on this? I know you have already addressed this a moment ago. Can you be more specific? Secretary, whatever scale reclamation under the existing ordinance or under the ordinance as amended, whatever scale it is in terms of reclamation, there has to be an authority that will be doing it, that we are talking about certain projects, even if we're talking about landing steps. We're not loosening up the restriction on all of them. You have to measure up to a specific dimension before we will be loosening up the restriction. Someone has to take the decision in any case. So the Chief Executive in Council will be taking the decision. We cannot say that you will only be allowed to do something that we loosen up the restriction on and not anything else. Now, let's say there is a pier proposed which will help the public enjoy the Victoria Harbour, but it exceeds the scope of the dimension. Now, we're talking about 0.8 hectares. What if it goes beyond that scope? Does it mean that we will poo-poo the idea? No, all piers will have to be confined to 0.8 hectares or below. Now, that's another unreasonable approach. So we are saying that if it goes beyond the scope as proposed, there must be some gatekeeper. Now, what criteria will be adopted by the authority? We have spelled that out in the bill. Now, Dr. Tick talked about public engagement. I said a moment ago that there is going to be a process for public engagement. Now, this is not confined to this bill. There are other areas like land acquisition, town planning, and so on. There is a statutory public participation process. Basically, we spell out the government's intention by notice in the Gazette, and we collect public views, and we do the analysis and present the details to the executive council. And this is the procedures that have been serving us well. We don't really want to micromanage and write into the bill too many minute details. Now, there are plenty of legislation that refers to public participation. I think we have to do it with the bounds of reasonableness. We heard recently comments from the public, or indeed from councillors, that the government is proceeding too slowly in taking forward projects, and it is like a non-stop loop of public consultation. So we have to strike a balance there. So this public engagement mechanism is actually on the same par with the other legislation. Mr. Bill Tang, I thank a dozen or so deputations for being with us. Basically, they are supportive of the legislative amendments, and they'd like to see this passed as soon as possible. and bring the harbour to the members of the public. And we should promote this water-friendly culture, and we should allow all manner of activities to be taking place in the harbour. Well, in fact, I'm not sure why the deputations are so worried. I think the government has made the Victoria Harbour too large in scope. In 1997, the PHO was enacted. The PHO was about the central part of the Victoria Harbour. But as a result of the amendments, the Victoria Harbour extends all the way to Chinyi Island, or Kwun Harbour Front, and the strip near the runway. This is also considered as part of the Victoria Harbour. So it goes to show that the government is far more determined in preserving the Victoria Harbour than we make it out to be. So there is a need for loosening up the restriction. Now, there is another issue that is also close to my heart. In Yau Tong Bay, it is proposed that a marina be put there, and there is a question as to whether the pontoon would be part of the seawall, or if we are talking about a removable pontoon, can this be taken out of the calculation? We'd like to take advantage of the Victoria Harbour for economic benefits. And it is an overriding need to stimulate economic development. Now, the basic question is whether the pontoon would be regarded as part of that. Secretary, whether floating pontoon, I don't think we are in a position to judge whether the single wording would be regarded as a reclamation project. If it is a reclamation project, would this fulfill the criteria for it to be put in the list for exemption? I don't think we should be too hung up on the wording, because the wording pontoon may mean different things to different people. Say, for instance, something is floating in the sea and it doesn't go all the way down to the seabed, then it doesn't involve any reclamation. But there are certain floating pontoon that is not just floating on the surface, because there are some devices that would link the device to the seabed, and by definition it would be a kind of reclamation. So we have to determine the size of the device. So I don't think we should look at it in too simplistic a term and determine whether this is really part of a reclamation. I do think the Bills Committee should be exhaustively contemplate all these possibilities. Reclamation can take different forms. There can be many different designs. I think we have to look at the overall situation. Now we have the specific dimension. We're not really plucking this out of thin air, because we have had regard to the piers that we built before, and all the sea walls and the boardwalk that we undertook before. We had regard to all these details. Now, when we come to these technical details, I'm prepared to talk to members in greater detail.
Next, Lo Wai Kwok. Chairman, thank you for taking time to all the deputations for coming to express your views. Whether you oppose or support the amendment, it shows that our guests today have shown the concern for our precious asset, that is Victoria Harbour. And we've heard proposals on how to better enhance the harbour, particularly along the harbour front, so that the public can have more contact with the beautiful harbour. Lately, I went to the boardwalk in North Point when we actually in LegCo vetted the request for funding for the project. We knew about the design. I supported it then. And when I was there in person, it was an experience that actually is exhilarating for me. I was really struck. Very few in the world, very few cities will have such a design, giving us so much space for us to enjoy. Just now I heard from the secretary that for some proposed mechanism, she offers some explanations. It's important for explanations to be given because for the CE in council to decide whether to have any rebuttal. The secretary said it well. It's not a new mechanism. You can imagine for a reclamation project, it would not just come out of the stone. Even if there were similar proposals in the past, the government is obliged to make some sort of judgment nonetheless. So if there are oppositions to a particular project and take the case to the court for final judgment, and that would still exist under the latest proposed mechanism. So the secretary explained well, and we need to avoid any misunderstanding about the latest amendment or to cause the public to be confused or misunderstood. So it's important for her to offer the explanation. On the whole, I feel that, of course, we're going to have the clause-by-clause scrutiny, but while the views expressed by the deputations are very good references for us. Thank you all. Ms. Lin, any response? I think there's no need yet. Yeah, just Mr. Low expressing his own views. The next is Chang Hok Fong. Thank you, Chairman. I'd like to thank our deputations today for expressing their views on the amendment. All the views expressed actually were also mentioned in our Bills Committee meetings. And we even gave the details. I was asking whether point 8 is multidimensional or just a graphic measurement, and whether outside of the 10 plus items where there are more possibilities allowed. So today's public hearing is a good occasion for the public to take part in the amendment process. It gave us a good opportunity for the secretary to give clear answers and to address concerns and queries. I need to express my gratitude to the secretary for clearly explaining the situation to us. I really appreciate her work. But I'd like the secretary to give us a more detailed timetable, because after the latest amendment, as mentioned by the Bureau, there will be projects as a result of the amendment to be launched. For example, in Kennedy Town, the boardwalk project there, or other projects. After the amendment, do you have a timetable for kicking off those projects so the public will know what will happen after the amendment is passed, so they can express their opinions then? Ms. Lin, Secretary Lin, after the amendment is passed, we do hope to carry out some projects. What are they? As I mentioned in a paper submitted to the LegCo, there is a schedule annexed with examples. Why? Because in recent years we've heard from the public, including, as mentioned by a member, the boardwalk in Kennedy Town, and also there is the in To Kwang Wan, Hong Ham. There are some projects to improve connectivity of boardwalks there, and also in Wan Chai along the harbourfront area, we want to add more steps so people can get closer to the water. All the examples in the list are intended for implementation. But as for the actual timetable, I think it depends on our public works schedule. But just to give you an idea of what projects we will want to kickstart first, I think those on the annex will be the plans given priority. But for the actual timetable, please give us space, and we need to plan for the projects for the coming year actually on an annual basis. Okay, I think members have asked for the first round. Those who want to have a second round include Dick Chi Yun. Let me clarify. Mr. Dick, I got it wrong earlier. Mr. Dick is not the member of the Bills Committee of the PHO Amendment Bill. So, Mr. Dick, you have 4 minutes. Thank you, Chairman, for giving me the second round. But, well, unfortunately, I couldn't join this Bills Committee, and I was lucky to have a chance to express my views anyway. Follow up to my previous questions, the purpose of the PHO is to protect the harbour, and that's the wish of the public. Over the past 20 years, we preserved the harbour well. It looks beautiful. And now, 20 years later, people would wonder, would there be any minor works that can be done by giving the government flexibility? That's the ultimate intention of the amendment, right? So, LegCo is now to give the power to the government. But is it too much power given to the government, undermining the protection of the harbour? So I'd like to also ask the Secretary, now, when you go for any harbourfront works or reclamation, you have the power, but in some places it's more complicated. Now you want to break down barriers. We can discuss that to give the power, more power to the government. But if there are excessive powers given, and yet, like in the case of Clause 3H, all the powers to be given to the CE in Council, can you explain to us if the 3H clause is passed, what does it have to do with breaking down barriers? What's the meaning of doing that? And also, making references to other ordinance in relation to public engagement, like for the town planning board, they have clearly spelled out explanations. So I would like to get more answers from the government. And if you cannot give me clear explanations, I may move my own amendments. So before Secretary Lin responds, let me say that I'd like to thank Mr. Dick for your concern for the amendment bill. Even though you're not a member of the committee, I do welcome your presence at our meetings to express your views. Secretary Lin? Yes, on the first question from Mr. Dick, all along, in moving the amendments, we have kept saying that it's for two purposes. One is that it seems that everyone supports our initiative to break down barriers. And on the other hand, for other projects, for the sake of other projects, we want to enhance the certainty of the system, and also to strengthen the gatekeeping role. If we just focus on the breaking down barriers side, and while just leaving various government projects to the guidelines and leave it to the departments to see where they can comply with the guidelines or how they can consult the public, then we would not be strengthening the system. We're not trying to strengthen the ability of the department to see what to do, but we want to give them procedures for them to follow. And it's not just for the departments to submit papers, documents to the Secretary for Development, but they need to submit the projects to the CE in Council. That's a very clear step intended to enhance the gatekeeping. I think the intention is very clear. We're not just breaking down barriers and disregarding the other aspect. That's why I kept reiterating that the latest amendment is to realize the government's obligation. It's not that we're happy now that hurdles are removed, but on the other hand, we want to strengthen the monitoring. And in terms of public engagement, Mr. Dick said he wants to make reference to other town planning procedures in terms of public participation and whether we would tie in with existing arrangements. We do welcome the Bills Committee in your discussions to give suggestions and to see what we should do. Next one is Andrew Lam. I think today, having heard from the Secretary on her answers for various key issues, I thought things were very clear already. I didn't think that she had not explained clearly or well enough. But it seems there are still lingering concerns. Firstly, as mentioned by the Secretary, right now, under the existing law, the decision-making power, nonetheless rests with the CE in Council. I will look at it this way and see whether the Secretary can maybe help us understand the situation better. Worldwide, the executive, legislative, executive, and judicial branches have their own roles. And in this making decisions on urban preservation or development, I don't know in where would the court be the final driver. Secretary said just now, she explained a bit just now, but I think we need clearer answers on that. In the Bills Committee meeting, I said this already, not to mention the Town Planning Ordinance, the other two ordinances in relation to preservation, the Antiquities and Monument Ordinance or the Country Parks Ordinance, the relevant decision-making power, does it rest with the CE in Council as well? If the answer is yes, then I would think whether for any particular reasons PHO has a different arrangement. And secondly, the views expressed by the deputations are a bit frightening to me. I just want the Secretary to explain, because there was the suggestion that the government has executive guidelines to follow now, even now. So why the need for Clause 3H? Secretary, you explained already you want to actually strengthen the gatekeeping, right? But actually, right now, is it that the executive guidelines are there, and yet with your tightening of the rule, how are they different from the executive guidelines? And are there any public participations in the implementation of executive guidelines? So under the current circumstance, how strong are the executive guidelines? Secretary, Mr. Lam asked us to compare the relationship between executive, legislative, and judicial branches in other cities and who make the final decision. That's a broader issue. I don't want to comment on the case of other cities, but to be pragmatic, looking at the latest amendment bill, throughout the years, the ordinance itself, the reclamation mentioned in the ordinance, as I just read out, the clause concerned states very clearly it relates to the power exercised by the executive branch. We have not changed the overall framework, so we're just trying to be more practical under the existing framework, which is unchanged. That's the fact. And in Hong Kong, often our policies are executive-led. And just now, Mr. Lam said the Antiquities and Monuments Office, how do we decide on whether a structure is a monument? And that's actually the decision of the executive branch of the government before it's gazetted. You may look at the relevant law and you will see who has the final say, which is actually a government department. And for executive guidance, many of them are around now in relation to dealing with reclamations. How strong are those guidelines? Details are in the guidelines, but they are guidelines nonetheless. They do not have a legal status. So we feel that in the future, if we want to tighten the monitoring, we need to put down in law that in the statutory timetable, statutory procedures, there are procedures to be followed. And if we need to change the writing of the law, then we need to come to LegCo for the amendment. And we're just trying to tighten the monitoring. Just now I said that we want to break down barriers for some projects. That is not a statutory process by itself, but who we should consult and what process to follow, it will still be spelled out in the law. And all these guidelines can be seen in writing. And we are very serious in, having discussions with LegCo members and to explain whatever you want me to explain for. Next one, Lo Wai Kwok, second round. Thank you. I just want to provide supplementary ideas. The Secretary, in relation to seeing Council having power on rebutting any project, so it's not really a new mechanism. It is what is actually allowed for. That is, the Seeing Council has the power already now. So I'm sure that their judgment would be based on the law and also be based on the public concern for protection of the harbour. And they would also try to strike a balance between construction and preserving the harbour and trying to strike a balance for the interests of the public. And I also like to add as well, and no one actually has mentioned the role of LegCo. Not just in vetting this amendment bill alone, LegCo, under the current mechanism, all public works exceeding $50 million in budget are required to seek the funding approval of LegCo, and then the project would go to the Public Works Subcommittee, and finally the Finance Committee need to agree on giving the funding support. So for all the reclamation projects in the future, they will still have to follow statutory procedures. I can't imagine a project that requires the approval of the Seeing Council would be under a budget of $50 million, right? So LegCo will also play a gatekeeping role. I promise to play a good role in that regard. So if the Seeing Council makes an inappropriate judgment, the public would definitely raise opposition, and we hear the voices. So I just want to say this to remind you not to forget the role, the important role of LegCo. We will be a gatekeeper as well.
意見啦。
Thank you, Dr. Low, for expressing your views. If the Secretary considers it unnecessary to respond to that, actually, I would like to give a response. If certain works exceed $50 million in value, of course, it would have to seek funding approval from the Legislative Council. But for projects that have a value lower than $15 million, LegCo has always been there to provide oversight. They can raise questions to the government whenever they want. So we are a government that is subject to serious oversight. Thank you. Thank you. We have completed receiving submissions from the public. I would now ask deputations and individuals to leave the conference room. We will continue with the meeting. We still have about 2 hours to go, but let's take a 10-minute break. Let's continue the meeting at 11:10, and we'll scrutinize the bill. Thank you.